what laws like Vermont's and other laws like it do effectively censor the type of information that we can provide. This is truthful, factual information. Courts have ruled that data even devoid of expression are entitled to free speech protection, and so we're very concerned that laws like this essentially allow the government to take a form of censorship and legitimize it. I think there are some misconceptions about how the information is used. We're the only ones in possession of the record, and so it's not freely available for others to try and re-identify a patient. But furthermore, HIPAA has a very important clause in it that is that it doesn't have a doctor component to it. And what the laws have attempted to do is define a right of privacy that simply doesn't exist. Now, I understand the perspective of the sensitivity of some of this information, but in terms of what we're trying to accomplish, we are not producing any information that is otherwise illegal to produce. One of the misconceptions here is this is a widespread concern on the part of physicians. There's an existing proxy in place for that physicians have redress in the 47 states that have not enacted similar type of legislation called the AMA Prescription Drug Restriction Program. It's available to all doctors, not just members of the AMA. And when you look at the statistics, you would think that if it was a real interesting type of program, ones that doctors zealously wanted to be a part of, 50%, 75% would have signed up for it. The current statistics as of last week, and this program's been out there for 4 years, and it's been advertised in over 70 medical journals, the statistics suggest that it's not really an interest for the doctors, and they understand that. 2.6% of physicians have signed up for such protection, and in Vermont, it's less than 2%. Obviously, the default is what we consider a concern because by essentially restricting the speech point blank, you're not giving the doctors who may be in the middle of this issue an opportunity to have their information used by default, and they may desire to have that done. The law does permit for academic research and formulary compliance, essentially all of the reasons the government would think is good for this information to use. What it does is it discriminates on one view, which is the marketing commercial use of the information is considered not so good, so we're not going to allow that to be used. I think our concern is with the default position, certainly being in the off position, but in general, I think to create a flow of information, transparency in the marketplace, all parties should be able to monitor other parties. All we're doing is we're publishing information. We shouldn't have to put black boxes over our data cells. Effectively, the law makes it harder, makes it less efficient. The most efficient form of communication is for a pharmaceutical company to understand who they're going to speak to and be able to communicate and educate them using an appropriate message. Should the court decide to uphold the law, I think there's going to be a lot of concern on the part of publishers in general. This is a law that once again suggests that there's something that the government doesn't like, and in order to create redress for this problem, they're willing to restrict speech if they can construct what they consider a compelling reason, which obviously we debate.